You decided to sue your doctor. Why is it that going to trial is dangerous not just for you and your attorney, but for the doctor and his lawyer as well? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. What I'm saying in this title is, why is going to trial so dangerous? And you might be asking, what do you mean dangerous? This is a civil lawsuit where you, the injured patient, are trying to obtain money as a form of compensation for all of the harms and losses and damages that you incurred, all because of the doctor's carelessness. Let me tell you why going to trial and having a jury of 6 people in the community, decide whether or not you are slightly more likely right than wrong is dangerous. Now, I don't mean dangerous from a physical standpoint where you are in danger of getting hurt or someone's going to hurt you. That's not what I'm talking about. I'm talking about a danger of the unknown. I'm talking about going to a jury verdict and having no idea whatsoever what the outcome is going to be. And that applies to you. It applies to the doctor whom you sued. It applies to your lawyer. It applies to the defense lawyer. It applies to the judge. Nobody in the courtroom has any idea how the jury is going to rule. And that's the danger of the unknown. You've now spent 2 or 3 years prosecuting your case, from the very beginning all the way through and including it up till trial. And now the defense has done the same thing. And the defense refuses to negotiate. They refuse to try and enter into settlement discussions, which means you now have to have a jury make a decision about whether or not you and your claim are in fact correct, whether you are slightly more likely right than wrong. If you are, the jury will then give you money to compensate you for the various harms and damages that you incurred. If they find that you have not shown that you are slightly more likely right than wrong, then they're going to tell you that and the doctor is going to win the case. The problem with going to trial is that you never know what the jury is going to do. There are 6 members of the community, people whom we don't know, who have biases, they have prejudices, and certainly some of them they're not going to share with us, but they come in with lots of baggage. And everybody comes in with their life's experience. And now they're sitting there to decide whether you are more likely right than wrong. There is a danger to allowing the jury to go ahead and decide your case. Now, what's the alternative? The alternative is that you try and negotiate, try and settle your case at some point throughout the course of the litigation. Now, here's the catch-22 that I'm talking about here in this video. The catch-22 is, listen, if the defense is not willing to negotiate, if they feel that the case is defensible, in that instance, you will likely have no choice but to go to a verdict. You will likely have no choice but to have a jury make the decision about whether you are right or whether you're wrong. So in that instance, you have no alternative. But where the defense is open to the possibility of negotiating your case, now you go into negotiations, and if they make a significant offer, now you have to weigh the risk of accepting a settlement offer compared to the unknown, what's behind door number 2. And the reality is, you don't know what's behind door number 2. Nobody does. And only at the very end of the case will you learn what's behind door number 2 and determine whether or not the risk-benefit ratio is worth it to turn down the defense's settlement offer and now take what's behind door number 2. And the risk is equal on both sides. The risk for the defense is that a jury comes back with a very significant verdict, way beyond what they thought the case was worth. The risk for you and your attorney is that the jury may feel that your case is worth only this amount of money, or they may feel you haven't proven your case. And as a result, they may throw you out of court without you getting a dime. So I show this to you just to open your eyes, to make you understand that, hey, listen, there are risks going forward to a jury verdict. And if you're willing to accept those risks and you're willing to gamble, then by all means, let's see what the jury has to say. You know, I do realize you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and still have questions about it before you decide to do that, what I encourage you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.